I'd like to begin by thanking Aviad and Noah for including me in this amazing conference. It's such an honor to be speaking, even if I can't be present in person, which I'm very sorry about. I'm sure this has been said many times already, but Yaron has been such an inspiration and such a generous mentor from the very first time I met him, even before I started graduate school. So I'm very grateful. What I'm presenting today is part of a larger research project which focuses on the legal disputes between Tunisia and Italy about the succession of Nissim Shamama, whom you already heard about from Yuval Haruvi. Nissim Shamama was a Tunisian Jew who died in Italy in 1873. I'll say a little bit about him since I'm not sure how much you've already said. But in any case, the larger project that I'm working on looks at questions of nationality, law, and the Mediterranean in the modern period. But today I'm just focusing on one aspect which has to do with the question of inheritance law, and particularly Jewish inheritance law in Italian courts. What I think is so interesting about the case that I'm looking at is that the ruling about the Shamama estate brings together two very different legal epochs in a single ruling. On the one hand, it's a modern civil court that is based on a modern civil code that supposedly applies to all equally, regardless of religion. And on the other hand, the ruling is about what Jewish law says about inheritance, that is, a religiously specific law for one group. So you have these two regimes sort of together. So what I'll do today is briefly outline the facts of the case to make sure we're all on the same page. Then I'll talk a little bit about Jewish law concerning last wills and testaments. And then I'm going to talk just about two Livornese rabbis, two rabbis from Livorno, Italy, who wrote extensively about this case. And then finally I'll speak about the final court ruling that was issued in 1883. So, facts of the case. You might have already heard some of this from Yuval. If so, I apologize. Nissim Shamama was born in Tunis in 1805, and he worked his way up to a position of some influence in the Ministry of Finance. There he made a lot of money, probably by skimming from the Tunisian government, and eventually he left Tunis first in 1864, first to go to Paris, and then to Livorno, where he died in 1873. Now, Nissim Shamama left no biological children. And after he died, they found a will in his house. And the will left half of his very considerable fortune to his favorite great niece, Aziza, and her son, who was also named Nissim. And then a quarter of the fortune was left to a nephew, and another quarter to a grandnephew. Now, this arrangement was very different from what some of Nissim Shamama's relatives had expected in Tunis, particularly a man named Shlomo Shamama, nicknamed Kaid Momo, who was Nissim Shamama's nephew and who was almost entirely cut out in the will. He was given like 25,000 francs, but had Jewish law applied to the estate, Momo would have inherited a third, right? So basically there were sort of two ways that the estate could be split up. Either it could be split up according to the will, which left half to Aziza, a quarter to a nephew, and a quarter to another great-nephew, or it could be split up according to Jewish law, which left a third to this nephew, a third to the great-nephew, and a third to Shlomo Shamama, the nephew who was cut out in the will. And all of this hinged on what Italian law would determine was Nissim Shamama's nationality at the time of his death, because questions of succession and other family law were determined by nationality. And it wasn't clear whether Nissim Shamama was Italian or stateless or Tunisian when he died. If he was determined to be Tunisian, then Jewish law would apply, because Jewish law was the law for Jews in Tunisia, at least for matters of family law and succession. Now, there's a whole lot to say about all of these issues, which I'm not going to talk about today, but suffice it to say that for our purposes, it's important that the that the final court ruling in 1883, which I'm going to get to at the end of the presentation, determined that Nissim Shamama did die a Tunisian national, and thus Jewish law applied. Okay, let me now say a little bit about the Jewish law of last wills and testaments, because, of course, throughout the various legal disputes regarding the estate, one of the questions at hand was, if Nissim Shamama was determined to be Tunisian, and if Jewish law was going to apply to the state, then what would Jewish law say about the will that Nissim Shamama had left? Now, Jewish law obviously sets out a whole bunch of guidelines in the Tanakh for how people should split up their inheritance, but there are various ways of getting around these by making a will. And the most sort of salient point for the halakha is the difference between the will made by a dying man, a shachiv mara, or the will of a healthy person. A man who is considered a shachiv mara, a dying man, is somebody who is ill and then subsequently dies from that disease. And that person is able, during his illness, to change the order of succession, to favor one among the various legitimate heirs, to give gifts to people who are not legitimate heirs by using the language of gifts. That's important. He can't say that this is a bequest. He must say that this is a gift. He can do all of these things. However, a healthy person is more constrained. If a person is healthy when he makes his will, then he must not make a bequest at all. The entire thing must be a gift. In Latin, the phrase is donatio inter vivos. Also, the gift needs to be effected at the time of writing, not at the time of death. In that sense, it's not really a will at all. It's rather essentially giving his goods now and until after he dies. Now, there are various sort of specific situations for wills that do change it slightly from just a regular gift, but I won't get into those now. But because it's essentially just a gift of a thing from one person to another, it requires a kinyan. It requires the ritual, symbolic acquisition of the property. Now, very quickly, I won't get into it in detail, but Shamama's will did not obviously conform to the requirements for the will of a healthy man. First of all, it's clear that Shamama was healthy when he wrote his will, at least by all normal accounts of what being healthy means, because first of all, he wasn't ill, second of all, he didn't die until 5 years later, and third of all, he says in his will that he was in perfect health. He does use the language of gift, at least for Aziza, though not for the other two nephews, but there is no kinyan mentioned whatsoever, and there is no sense that he is giving this property now, but rather he is giving it for after his death. So on the face of it, there are significant problems with accepting this will under Jewish law. Now, I want to talk about two rabbis who were hired by opposite sides of the litigation to write lengthy opinions about whether the Shamama will was valid or not according to Jewish law. The first is Elia ben Amozeg, the older one is Elia ben Amozeg, who was born in Livorno in 1823. He had a traditional education. He taught at the Collegio Rabbinico di Livorno. He was a rabbi and an observant Jew and a very influential thinker, especially when it comes to mysticism. And the other was his student, a man named David Castelli, born 13 years later, and also Livorno, who studied at the Collegio Rabbinico di Livorno, and who subsequently sort of rebelled against his traditional education. And rather than becoming a rabbi, he learned philology. He became very influenced by Wissenschafts des Judentum. And in this way, he became very at odds with Elia ben Amozeg, his teacher. In 1876, Castelli was appointed a professor of Hebrew at the Istituto di Studi Superiori in Firenze, and he was not observant. He was cremated at his death in 1901, just a year after ben Amozeg died. These were two of the sort of leading luminaries of Jewish thought from Livorno at the time, and each of them were hired by opposite sides. Castelli, the younger one, was actually hired first by the Tunisian government and the, quote, legitimate heirs, that is, the heirs who would have inherited according to biblical law. And Castelli wrote a very large number of opinions about the Shamama case, all of which basically argued more or less along the same lines that Jewish law could not accept this will as valid. Again, I don't want to get too deep into the details because otherwise we won't have time for the stuff that I find really interesting. But in general, Castelli insists on a very strict division between a sick person and a healthy person. And he says that the kind of will that Nissim Shamama made was clearly that of a healthy person, but it doesn't have a kinyan and it lacks all these other requirements, and therefore it is not valid. Ben Amozeg wrote a very different kind of opinion about the will, which argued the opposite, which argued that actually the will was valid. And while Castelli's arguments followed many of those that were written by Tunisian, Palestinian, and rabbis from elsewhere, Ben Amozeg's was really quite unique. He argued that Jewish national law is only that law which is found in the written and oral Torah, meaning Tanakh, Mishnah, and Talmud, and that all of the rabbinic writings after the Talmud are merely commentary and opinions, but do not hold the weight of law. So whereas Castelli looks at texts like the Shulchan Aruch as an authoritative text in the development of Jewish law, Ben Amozeg says really the Shulchan Aruch is just another opinion. And thus Jews not only have the right, but the duty to study the sources of law themselves, and they're not required to follow the opinion of any particular rabbi, even if he's very illustrious, unless they agree with it. And he, of course, argued then, he went on to argue that according to his interpretation of the Talmud, there is nothing wrong with the will that Nissim Shamama wrote. He emphasizes Dina de Malchuta Dina, the law of the state is the law, and says that Jews have always had to obey the law of the country in which they live, etc., etc. Okay. These were, I think, two of the primary sources of information for that informed the judges who ruled from the Court of Appeal of Florence in 1883, because those judges were Italian judges. They obviously didn't read Hebrew. Most of the halachic debates about the validity of the will in Jewish law went on in Hebrew, and these were two of the few that went on in Italian. Now, the ruling is very interesting. Principally because rather than follow any of the many rabbinic opinions that were published about the case, either in Italian or in other languages, the ruling essentially goes back to the original sources, the Mishnah, the Talmud, the Shulchan Aruch, the Tur, etc., and comes up with its own interpretation for what it thinks Jewish law says about last wills and testaments. First of all, the ruling does acknowledge that the Mishnah makes a distinction between sick and healthy testators, but it argues that certain Mishnaic passages refer to both sick and healthy testators. Passages that most rabbis, like Castelli, like many of the Palestinian rabbis who weighed in, like the Tunisian rabbis, passages that these other rabbis interpreted as applying not to sick and healthy, but only to sick testators. So the ruling concludes that healthy people can change the order of inheritance, that they can change the amounts or favor a non-heir using the word gift, etc., etc. It also comes to the conclusion that a kinyan is not necessary either for the will of a sick person or for the will made by a healthy person. And for this it quotes the Tur and the Shulchan Aruch, and saying that as long as a person does not change his mind after he makes a gift, his gift is valid whether or not he does a kinyan. As far as I can tell, this is not an opinion that I've seen reflected in any of the halachic literature, though perhaps I've missed something. Any of the responses are written by Jews about the subject, but this is the conclusion that the Italian court came to. And then finally, and most importantly, the court gives an evolutionary argument, and it stresses that Jewish law had to evolve over the centuries in order to be a living law, right? That it couldn't be fixed in these texts that were written in, thousands of years ago, that it had to change and evolve. And it gives examples of how Jewish law evolved, like the influence of Roman law on Jewish law, etc., etc. And the judges explain that the reason that these subsequent rulings from the Mishnah and the Shulchan Aruch and other texts allow a healthy person to essentially bequeath their goods as they would like is because Jewish law adapted to a world in which people had private property and they wanted to be able to do what they would with it. So in short, as far as I can tell, the judges of the Corte d'Appello di Firenze came up with their own interpretation of Jewish law, one that was obviously in some ways informed by the opinions of Italian rabbis and their translations of Hellenic sources, but not at all identical to any of these opinions, and not ultimately really resting on them. The ruling does not quote the authority of contemporary rabbis. It only quotes the authority of Jewish texts. This is interesting in part because it shows that the Italian court was willing to actually have a very positive view of Jewish law, right? It saw Jewish law as something that was evolving, that could adapt to historical circumstances, and thus rejected a view of Judaism as sort of stuck in time. Yet, in doing so, in cultivating this positive view of Jewish law, they also declined to follow the opinions of any contemporary Jewish jurists and essentially declared themselves competent to interpret Jewish law on their own. Now, by way of conclusion, I want to talk briefly about how the ruling of this court on the Nissim Shamama case compares with other instances in which Jewish law ended up being ruled on by modern European courts. And again, we have a sort of trans-Mediterranean situation here. This essentially, as far as I can tell, only happened with any regularity in France after French rule began in Algeria. Because between the years 1830 and 1871, when Algerian Jews became French citizens, Jews in Algeria remained under Jewish law for matters of succession and personal status and marriage and divorce, etc., etc. So there were a handful of cases that originated in Algeria and then they made their ways up to various courts in France, including even the Supreme Court in Paris, concerning whether Jewish law applied to matters like succession. And in some of these cases, the court had to determine how Jewish law ruled, right? There's one case from 1855, Femme et Gedra contre Zerafa, a case in which a man died leaving no children, and the question was whether his mother could inherit from him or only his paternal relatives. Now, first the court ruled that Jewish law applied, and then ruled that the mother could not inherit, but lamented how unfortunate this was, saying that it was really too bad that Jewish law was so maladapted for modern times and that only the male relatives could inherit, etc., etc. Now, this is interesting. In some ways, it's similar to the Shamama ruling in the sense that it's a modern court based on a civil code, which nonetheless ends up ruling on a matter of Jewish law. On the other hand, it's very different because it chooses to interpret Jewish law to reflect a sort of staticness about law rather than the Florence ruling, which saw Jewish law as evolving and adapting to modern circumstances. So in conclusion, what we see in these cases of Jewish law ending up in these modern European courts in these sort of trans-Mediterranean disputes is an instance of the meeting, as I said earlier, the meeting of civil law and religious law. Interestingly, the Italian court's interpretation of Jewish law ends up being very influenced by its desire to see Jews as a people with a modern, evolved legal system. Now, this approach was not necessarily obvious, and it shows something about at least the way this one court wanted to interpret Jews and Jewish law, right? They certainly could have gone the other way. Jewish law on wills would, in some ways, more easily have lent itself to declaring the will invalid. And in some ways, the state, as in France, seemed to, in certain instances, benefit from seeing Jews as kind of retrograde and stuck in time. So what we see is the sort of multiplicity of ways in which Jewish law could end up being interpreted by modern courts, which I think is a really fascinating sort of moment in the transition, you could say, from a kind of early modern legal pluralism to the sort of modern nation state with its civil codes. Thank you so much for your attention, and I look forward to questions.